Now on to the discussion on the impact of corporate activities and sources of accountability. This panel will be chaired by Professor Michael T. Chu Jr. And while they're setting up the stage, allow me to introduce the chair as well as the panelists. The chair of the panel is the National Rapporteur for the Philippines in Bicol's Global Toolbox on Corporate Climate Litigation. He is an assistant professor of the UP College of Law, and he is concurrently the head of the International Criminal Law Program of the UP Eales and the head of the UP Law IPD. He's a legal consultant with the UN on drugs and crime under the UN Joint Program for the Promotion and Protection of Human Rights in the Philippines. He continues to be a resource person of the Commission on Human Rights on matters involving international human rights standards, and he is also a member of the Philippine Working Group on Business and Human Rights. Joining him as panelist is first Honorable Lady Ivy Vanity Velasco, Judge at Large for the First Level Courts and acting presiding judge for the Metropolitan Trial Court Branch 56, Malabon City. She graduated with a Bachelor of Science in Business Administration cum laude and Juris Doctor degrees from the UP Diliman. She completed her Master of Laws from Columbia University, New York, USA. Judge Velasco is a member of the International Experts Group convened by the National Rapporteur for the Philippines of the Bicol. Another panelist, may we request Judge Lady Ivy Velasco, please, to join Professor Mike Chu on stage. Another panelist is Dr. Robert DiFilippo, an assistant professor at the National Institute of Geological Sciences at the University of the Philippines, with interests in groundwater research in vulnerable environments, with a specific interest in the effects of climate change in coastal communities in low to middle income countries. May we request Dr. Filippo, all right, he went out for a bit. Right. Our next panelist is Professor Jacqueline Joyce F. Espenilla. She is the director of the University of the Philippines Institute for Maritime Affairs and Law of the Sea because she was just promoted by Senior Associate Justice Leonen. And she's also assistant professor at the University of the Philippines College of Law. Her research focuses on the South China Sea disputes and more broadly on maritime safety and security in the Asia-Pacific. She received her LLM from Harvard Law School and her JD and BA from the University of the Philippines. Our other panelist is Ms. Briony Eales. She is an Australian solicitor specializing in climate, environmental, social, and governance law. She is currently the consultant team leader for judicial capacity building in environmental and climate change law at the ADB. Her program had been instrumental in supporting judicial exchanges across Asia and the Pacific through the creation of the Asian Judges Network on the Environment and Regional Judicial Conferences. Next, we have with us Attorney Antonio A. Oposa Jr., who prefers to join the panel discussion while sitting amongst our participants. So he's over there. Attorney Oposa Jr. is the president of the Law of Nature Foundation. He is one of Asia's leading voices in the global arena of environmental law. He pioneered the practice of environmental law in the Philippines, and his work is known locally and internationally for establishing in the highest court of law the principle of intergenerational responsibility, that this present generation has a responsibility to protect the environment for future generations. And of course, we would also like to welcome, Dr. Masako Ichihara. She is a researcher at the local Climate Change Adaptation Center in Kyoto. She is the National Rapporteur of Japan at Global Network of Peer Reviewers on Climate Litigation at Sabin Center for Climate Change. Joining us online will be Advocate Momita Das Gupta from Bangladesh. So, Momita Dasgupta is an advocate affiliated with the Supreme Court of Bangladesh and working as a research fellow of Center for Climate Justice in Bangladesh. She has completed her LLB and LLM from University of Chittagong. There you are. So,
All right, thank you very much. And Attorney Tony, please feel free to intervene whenever. We see you there, so I'll just call on you later. So what we'll do with this panel, and I think you've had a glimpse of theorizing what types of cases will come to the court and suing corporations. I want to acknowledge before I proceed the presence, of course, of our colleagues from the Philippine Judicial Academy, Attorney Dev, Attorney Galahad, and then, of course, our colleagues from the Commission on Human Rights, who is also representing the chairperson today, Ms. Agnes from the First Philippine Holdings Corporation. So you've seen from the keynote of the Senior Associate Justice that cases come to court on different theories, and we've had some success in some of those theories, but mostly not. And this is really where we'll talk about this panel. We'll talk about the developments in theorizing these cases when they get to court or before even they get to court to see whether there is a chance of success, at least across the Asia Pacific, which was the focus of this conference, but we'll also be hearing insights from cases elsewhere in the other regions that are also part of the toolbox. And what we'll do is we'll give our panelists about 5 to 7 minutes to introduce or have opening remarks or insights on climate litigation in general and specifically on causes of action, and then we'll get to our discussions. And I would like to begin with Dr. DiFilippo on climate change and water rights.
Well, thank you. As a hydrogeologist and practicing scientist in the field, I spend a great deal of my time working with communities throughout the Philippines who are dealing with water scarcity and water stress on an unprecedented level. And the question is, how do we link that impact to causes outside of their control? And in some cases, experience falls on decisions made by local government in terms of water access and water rights, and how they fall upon economic drivers, and sadly leaving communities behind. And that may seem inconsequential because that causes jobs, it causes increases in economy and GDP, but what's not being factored into the decision making is the changes in climate and how those changes are altering patterns of groundwater sustainability. And those patterns lie on rainfall and how we analyze rainfall data and climate data that's actually being altered due to climate change throughout the archipelago. And also we see an increase in demand. When we look at statistics and we see that in the National Capital Region, it's purported that almost 70% of the NCR is receiving water. And that's what the national government uses as a statistic. When we go down to the local government unit, we learn a lot more. It could be closer to 20%, 25% of the population. And as their hand-dug wells are drying up, and not just during the dry season, which is actually expanding as a result of climate change, their availability or access to water is being challenged. And as a scientist, we study the effects of this on whether it's a freshwater lens or whether it's a continental aquifer. But what we fail to sometimes integrate is the health impact on this. So when I go out in the field, I not only speak with the MPDCs for these local government units, I speak with the municipal health officers to learn about whether it's a cholera outbreak that may not even be reported, or diarrheal disease that's more common, or children missing school. So this is an impact that, as our keynote speaker mentioned, obviously I'm an advocate and I have a great deal of empathy, but I'm challenged to draw more on science to help bridge the gap in advocacy to actually make a real change. Thank you.
Thank you very much, Judge Velasco.
Thank you, Attorney Tu, and thank you, Professor Froy, for the introduction. Can I get some assistance on the deck, please? Thank you. So allow me to use, good morning, everyone. Allow me to use the next 7 minutes first to attempt alignment by sharing evidence on how the Philippines experiences the climate emergency, and second, to share observations on select jurisprudence related to the environmental duties of corporations. When climate change started making news cycles, there was a lot of skepticism. It was not helpful that climate denialism operated in the same way that Big Tobacco. They had campaigns refuting the carcinogenic effects of cigarettes. But can we go to the next slide, please? There, thank you. But sound verifiable science, however, has provided proof that climate change is real. That's number one. And that the greenhouse gas emissions of corporations is the major anthropogenic cause for the dangerous rate at which it is happening. In the Philippines, mean temperatures are increasing by 0.1 degrees Celsius per decade. And this causes a corresponding acceleration in the increase in the variability and intensity of rainfall and the strength and frequency of extreme weather events like super typhoons. Case in point, Yolanda, with 314 kilometer per hour winds and a storm surge that caused 6,300 deaths, 4 million displacements, estimated damage of 95.48 billion pesos, and estimated losses as much as 4.6% of our GDP. We are also experiencing slow onset events, and this is something that Dr. Philippine touched on. This include ocean acidification, the loss of biodiversity, the rise in sea levels. And this is what we see here. Dr. David, who is also to be part of the panel, and her team has found that the Philippines surpasses the global average by 300%. That's a lot because sea levels are rising by 7 to 10 centimeters per decade. This exposes the vulnerabilities of coastal areas, such as what you see here. This is Isla Pamarawan in Bulacan, where the residents suffer the detrimental effects of the year-long exposure to flood water and the threat of being submerged by 2050. It is therefore no surprise that the Philippines ranks fourth in the global long-term climate risk index, which means that the Pag-asa projections of more droughts, more floods, and more storms are within the realm of proximate occurrence. More recently, in 2023, the Philippines was ranked first among 193 countries in terms of disaster risk. And based on indicators for exposure to extreme weather events and slow onset events, as well as for indicators for resilience, coping, and adaptation capacities. And so we ask ourselves, how did we get here? Through various studies, it was determined that China, the United States, India, the EU, Russia, Brazil account for 61.6% of the global GHG emissions, and that 25 corporations are responsible for more than half of the GHGs released into the atmosphere. On the other hand, the Philippines, it's a low emitter. It only has a cumulative CO2 emission making up 0.21% of the total emissions since the year 1750. Surely, there is a blatant injustice in the disproportion of the emissions, the cost, to the injuries, loss, and risk. Thus, with the reparative ends of compensating for harms, mitigating effects, building adaptive capacities, it makes imperative sense that we elevate climate justice as a priority agenda. And we can do this through climate litigation. which is not only an avenue to obtain pecuniary reliefs, but as the IPCC proclaimed, it is one of the several important new ways to shape climate policy. And so I invite you to examine potential cases with the parallel paradigms of causes of action, remedies, and reliefs, because as Professor Chu mentions, these are interdependent, and because experience has proved that having an end in mind is useful in choosing the best course of action. I borrow a few elements in this graphic from the framing of the University of Notre Dame and also from the BICO. There is a reparations lab, and this is for your own resource, co-headed by Professor Diane Descherto, and they are tracking cases all over the world using human rights as a framework in pursuing corporate liability. I add to this the imposition of fines because this became the subject of 3 consolidated petitions in 2013. In the case, the Supreme Court found that the corporations Maynilad, Manila Water, and MWSS violated the Clean Water Act because they failed to provide a centralized sewerage system within the 5-year compliance period and thereby caused the continued release of wastewater into water areas such as Manila Bay. They were held solidarily liable for fines, and this imposition became compelling because there was a daily multiplier and there was a percentage annual increase. Now, 2 years later, in 2015, the Supreme Court nullified the corporation's service agreement. The court held that service contract 46 with Japan Petroleum is unconstitutional because it was the DOE secretary and not the president who signed the agreement. The court also found that Japan Petroleum conducted seismic surveys in Tañon Strait, a strait that's between Negros and Cebu, without an ECC, and this is a violation of environmental laws, the NEPAS Act and PD 1586. However, the first case really about carbon emissions is Segovia in 2018, where the petitioners invoked their right to a balanced and healthful ecology and pursue this through applying for a writ of kalikasan. But that was ultimately denied because they were not able to prove that there were unlawful acts or omissions committed by respondents reasonably connected with the violation or the threat to the right. Now, I will be remiss if I don't mention the phenomenal work of the Commission on Human Rights, because in the national inquiry into climate change, the CHR did identify rights and trace them into their international and municipal expressions. And these are those rights. Now, these are possible jump-offs for climate litigation. And before I end this, I just wanted to say that I do look forward that in the next couple of days, these discussions that we're having, they will be a step in the right direction, because we can endeavor to expand our understanding, we can rekindle our hope, and hopefully inspire our action. And with that, I yield the floor. Thank you.
Thank you very much, Judge Velasco. So we've had 2 perspectives from science and the judiciary. Now let's go a little bit more international with Professor Jackie's intervention on what is happening at the IT laws and other areas of international law.
May I please have my slide deck? Good morning, everyone. I have a PowerPoint presentation, a short one. This is not so that I will speak longer, but so that I will speak shorter. This is a subject that I love talking about, so please forgive me if I get into it. So as Professor Tiu mentioned, I wanted to bring the discussion a little bit more blue. When we think or frame climate change issues, it tends to be terrestrial or atmospheric. For whatever reason, they tend to forget that the oceans is a very critical part of this conversation. So for my presentation today, I want to talk a little bit about UNCLOS and the BBNJ agreement. Perhaps UNCLOS you've heard of, I hope so. BBNJ agreement, unlikely because this is very new. So allow me to give a quick backgrounder on what these 2 instruments might have on our current conversation. All right, so the 1982 United Nations Convention on the Law of the Sea is, as we know, the so-called Constitution for the Oceans. If we want to talk about regulating activities in the oceans, this is the framework instrument that sort of gives us guidance on how to create laws, to how to sort of protect the marine environment. It's basically a hodgepodge of issues that are all captured in this one instrument. But because it is a framework instrument, it tends to be overbroad. As a result, 3 subsequent implementing agreements were thereafter adopted so that it gives a little bit more meat to the obligations found in UNCLOS. The first is the 1994 agreement regarding the Part 11, which, just to sort of simplify it, is all about deep seabed mining in the areas beyond national jurisdiction. So it's not occurring within your own national territory, your own national borders, but in the far, far regions of the ocean. And that's something that we will not discuss this morning, but it is in fact very controversial. The next is the 1995 UN Fish Stocks Agreement. This is an instrument that talks about fishing, which is actually the main reason why UNCLOS was enacted in the first place. So it is a very controversial resource that occurs not just within national jurisdiction, but in the high seas. Fish know no nationality. They don't have passports. Of course, they swim everywhere. So of course, there may be issues here about resource use and allocation. And the last one, and this is the one that I was mentioning earlier that's very new, it was just enacted last year. Opened for signature last year. This is the BBNJ agreement. It actually is short for a very long name. It is the Agreement on the Conservation and Sustainable Use of Marine Biodiversity in Areas Beyond National Jurisdiction, so we won't call it that. It is the BBNJ agreement. It speaks, once again, of a grab bag of issues about protecting and conserving the marine biodiversity in the high seas and in the deep seabed. So I'll get to that in a little while. But first, going back to UNCLOS itself, the mother instrument. One thing that you should be familiar with is that there was very recently a decision that was handed down by the International Tribunal for the Law of the Sea, an adjudicative body created under UNCLOS. And this is very relevant to this morning's discussion, because it is the first advisory opinion on climate change. And it has as its basis 2 obligations that I want to highlight found in the UNCLOS, and these are the environmental obligations. So UNCLOS tells all states that there's a general obligation to protect the marine environment. Again, very broad. So this advisory opinion was very instrumental in clarifying exactly the content of this obligation to protect the marine environment. And second, there's also an obligation to adopt measures to prevent, reduce, and control all sources of pollution of the marine environment. UNCLOS is very long. If you go through all hundreds and hundreds of provisions of the UNCLOS, you will nowhere find the words climate change, GHG emissions, or anything that is sort of common language in the climate change discussion. But in this case, the one that I just mentioned, this UNCLOS, case number 31, the advisory opinion requested by the Commission of Small Island States, it exactly asked the court to clarify whether or not UNCLOS is bearing on this climate change conversation. The most, if there's nothing else that you want to take away from this decision, it's this. The International Tribunal for the Law of the Sea told states that they have specific obligations under the UNCLOS to prevent, reduce, and control marine pollution from anthropogenic GHG emissions and to endeavor to harmonize their policies in this connection. What the court was effectively saying, and here's the first takeaway, is that it clarified that when you speak of marine pollution under the UNCLOS, this in fact covers GHG emissions. So a modern day problem covered by the broad overarching language of a 1982 instrument. They basically went through all of this, and if you care to read, there's may kodigo ako. Paragraph 161, for you to refer to immediately, tells you the elements of what constitutes marine pollution. And if you go through all of that, it does squarely cover GHG emissions. And then again in paragraph 178 of the decision, it also reminds us that GHG emissions do cause deleterious effects that do have impact on the oceans. By a matter of reference, the ITLOS advisory opinion does refer substantially to a lot of the IPCC science-based discussions on GHG emissions and already adopted that in the main body of the decision. The second takeaway that I'd like to just quickly highlight for you is that the tribunal highlighted that states have a stringent due diligence obligation to prevent, reduce, and control marine pollution. due diligence here is sort of a moving concept. It is case-based, it is fact-based, and is something that the states are given leeway to consider first, availability of the best available science, the means and capabilities of states, and other relevant rules and standards. So it's not a fixed thing, only that it must be part of the sort of the actions that are done by states. The due diligence obligation is always necessary. So I'll leave that issue of the tribunal later, and I'll conclude in a little bit and tie it back to that. But for the moment, allow me now to move to the 2023 BBNJ agreement. It is what I like to think or call as the most important international treaty that no one has ever heard of. Why? This is the world map, as you can see. 71% of the Earth is covered by the ocean, and 64% of the ocean is considered the high seas or international waters. That's all the dark blue parts of the ocean. Imagine all of those dark blue parts of the ocean going, for the most part, unregulated, and that, of course, can be a problem. The high seas cover about 45% of the Earth's surface, and you can imagine how much of human activity actually occurs in those so-called unregulated spaces. The BBNJ agreement kind of steps in to fill that gap. The four main elements of this instrument are as follows. First, it talks about marine genetic resources, a technical term which just basically means the fundamental building blocks of marine biodiversity, living things found in the ocean. Not the whole fish itself, but rather parts of fish, the DNA of fish, things from which you can extract commercial value. For example, pharmaceuticals, makeup, important yun, are in fact based on the marine genetic resources that are found not just in marine resources, but also in all living things, generally speaking. Next element is our area-based management tools, including marine protected areas. MPAs are the best example of ABMTs, but of course there are others, such as marine spatial planning or any other activity which might take into consideration the application of more stringent protection measures in a fixed or given area. Third, environmental impact assessments, and I'll get to that in a while. As you can see from the orange underline, that's important. And fourth, capacity building and the transfer of marine technology. The oceans is inequitable at the moment. We have a lot of issues concerning the global north and the global south, and UNCLOS tried to remedy that, but not entirely so. So this new agreement proposes to ensure that there's more opportunities for countries like the Philippines or small island states to participate in lawmaking and regulation and protection of the environment. All right. Oops, sorry. So environmental impact assessments. And I wanted to highlight this because it has a special bearing on climate change litigation. Why? The UNCLOS sort of gathered together all the existing law, international and domestic law on EIAs, identified best practice, customary norms on EIAs, and basically made it a central repository for these ideas. It identified a tiered approach, meaning stepwise, as to how you would be able to conduct an EIA in the high seas. You can already imagine how much of a logistical challenge that might be. So there are some issues that sort of take that factor into consideration. So just as a quick rundown, there are 3 stages identified in the BBNJ agreement. First, there's a pre-screening process. Again, the idea here is that not every activity will be subject to an EIA under this instrument, again, because it's so impractical to do that. So only activities which would have more than a minor or transitory impact, or the effects of the activity are unknown or poorly understood, would be, in the first place, subject to this question: should we assess it? If the answer is yes, you proceed to the second step in this tiered approach, which is screening. Once you have already identified that, yeah, it's going to have a more than minor or transitory effect, you then consider whether or not the activity may cause substantial pollution of or insignificant and harmful changes to the environment. Sorry, that's long. And again, if the answer here is yes, only then will you progress to the final step, which is a full EIA. That requires time, that requires resources, that requires a whole lot of science. So unless and until you satisfy those triggers for proceeding to a full EIA under the BBNJ agreement, you will not. But again, compare that to the present day, wherein the requirement for a full EIA in the first place is not subject to such standards. There's no basis for triggering it, unless, of course, the country, the state to which, let's say, the vessel belongs to has some sort of clear triggering mechanism. So there is no uniformity. So this provides some predictability to this requirement of an EIA obligation. Now, what does this mean for corporations? And tying it back now to our present-day discussion. Because you have an ITLOS advisory opinion telling states that it's part of your due diligence obligation to create a national system to lessen, mitigate, or completely prevent GHG emissions, plus you add that to this new treaty, which, assuming it takes or enters into force, tells you that now you must have, again, measures to have full EIAs, or a system for requiring entities within your jurisdiction or control, corporations, to subscribe to an EIA process, now brings us to the conclusion that now, first, there will now be stricter requirements and controls by states over the activities conducted by companies under their control or jurisdiction. This covers a lot of potential entities: shipping entities, fishing companies, submarine cables, offshore energy, so wind, tidal energy, things like that, aquaculture, even those who purport to do good things, such as companies who will engage in carbon sequestration businesses, or let's say geoengineering in the oceans, seabed mining, among other things. Also, these two new developments in the law of the sea tells us that there are now new mechanisms for the declaration, authorization, and reporting of activities to authorities. So states will probably start thinking about having these kinds of policies. States will also consider having requirements for EIAs prior to the operation of activities, whether it be within national jurisdiction or in areas beyond national jurisdiction. The interconnected nature of waters means that even if the measure only applies to domestic waters, it's entirely possible that there may be transboundary impacts elsewhere. So the strict due diligence obligation requires that even domestically, you would conform to these new policies. And of course, there's also the requirements for the monitoring and reporting of activities and impacts. There are now currently such measures, but now probably more detailed, more elaborate, and more regular. And finally, the assessment of cumulative impacts. So for those who are familiar with the language, strategic environmental assessments will also now become part of the normal process of things. It will allow you to consider broader issues beyond the immediate impact of a project or activity, such as climate change, acidification. So it makes you think holistically of the potential impacts of your activities. All of that to say is that these are now new potential bases for liability of corporations. So I think I'll end here. Thank you.
Thank you very much. And we'll come back to that when we talk about domestic suits that could use this as a basis. But for now, let's go to Briony, who's done extensive work on climate litigation in the region, and hear her insights.
Hi, everyone. Can you hear me? Yes. I apologize for my voice. I have asthma from Manila's pollution and heat. So I do apologize. So it's such a pleasure to be here. Thank you so much for inviting ADB to participate in this panel, and I'm honored to be in a room with luminaries. And I'm going to start with 3 key points that I will expand on in respect of corporate climate litigation. So in understanding the emerging areas of law, and litigation, it's always going to depend on a country's particular circumstances, legal frameworks, and litigation preferences. So in Asia and the Pacific, we're more likely to see people targeting, looking at water or particular aspects to prevent impacts, because mitigation is not as important for many countries who are low carbon emitters. Corporate climate litigation is a big trend. It's a growing trend. It's not going anywhere. And it fundamentally reflects the need for urgent climate action, but also gaps within the legal system. And those gaps also reflect the kinds of litigation that we tend to see. And thirdly, we need innovation in the law. We need innovation in the courts. Associate Senior Justice Leonin has touched on that. Relaxed rules of standing, use of writs of continuing mandamus. Litigation against corporations has been difficult because attribution science has been a growing area, but with developments in that, it is becoming easier to attribute liability to corporations. But causation is always going to be a challenge. And I'm going to say this, the law of torts is great. I come from Australia, we use it all the time. It typically focuses on after the fact remedies. But we're looking at climate change, and we want to prevent the worst impacts. So torts, when we're thinking about how to litigation and the results we want to see, often it's preventative litigation that we might want to be engaging in. So let me expand on what's driving the whole environment. We're still seeing an alarming emissions gap, right? So the gap between the Paris Agreement targets and what we see in national pledges, current policies, and policy outcomes. So greenhouse gases need to be cut by 43% by 2030 against the 2019 baseline. That's halfway to net zero in 6 years' time. Climate pledges in the next round of NDCs, which are due in February next year, roughly need to improve by 5 times. We need to get 5 times better by 2030. And we also need to start seeing better alignment with different legal frameworks. So it's not just climate change, it's the biodiversity legal frameworks. We now have the Kunming Montreal Biodiversity Framework Agreement with a 30-30 target. So 30% of degraded land needs to be improved. Countries need to find 30% of their land to protect. That's going to impact climate change, but it's also going to result in just transition litigation. So the private sector is really critical in helping. It's part of the solution, but there are really significant risks that companies face, and there are uncertainties in the legal frameworks. Sorry, I've just lost my place in my notes. Only 25% of Asian and Pacific countries have a framework climate law. Importantly, as of 2023, not one country had a law that had a net zero obligation on corporations. So what are you supposed to do as a company? Like, this is coming down the pipeline. And such laws are clear, like I said, they're on the pipeline. And the recent case of the European Courts on Human Rights, you would have heard of the Swiss women for the protection, climate protection. And that shows us why, in that case, the Human Rights Commission said that states have a duty to adopt regulations or measures capable of reducing emissions and achieving net neutrality by 2050. States can't get there unless they regulate companies. Also, at COP this year, we're going to see, hopefully, some agreement on the global goals for adaptation. They're still not there. So there's all these gaps that companies have to deal with. But just recently, there was a report published. They do it every year. The Grantham Research Institute looks at a global snapshot on corporate and global climate litigation, and that gives a really nice summary of the different types of corporate climate litigation that we are seeing. So climate washing, greenwashing, is the biggest form of climate litigation against companies right now, and 70% of those cases have been successful. And climate washing is really when companies announce to market, hey, we're green, we're friendly, but they're really not. They don't have policies in place capable of achieving that. Corporate framework cases are also big. You would have heard of the case of Milieu Défensi against Shell, and that's an example of a case asking a company to align its goals, its policies, and its outcomes with the Paris Agreement. We're seeing damages based on polluter pays principles, and these are these climate attribution cases that are difficult, suing companies for the impacts of climate change and for damages. We're also seeing cases looking at corporate responsibility for climate risk. These are the types of cases where we see company directors being sued over what are the corporate policies, how are they aligning the corporate goals and policies with the Paris Agreement, and what are their obligations to do so? And a last area that will become bigger, and I think it could become big in a place like the Philippines, is transition risk. I hesitate to touch on it because it is so sensitive, but look at what's happening with the jeepney drivers. It's so complex, but it will result in litigation. And then things like in the UK, the Butler Schloss case, where a board sought a declaratory opinion to say that its investment plan was legal for aligning with the Paris Agreement, because companies are also becoming concerned about the backlash against them. And so they're saying, we want to be Paris Agreement aligned. Is this legal in the current framework? So there's different types, as I said, of corporate climate litigation, and I'd love to stick around and discuss more about what those implications are.
Sure, thank you very much, Briony. And just a small note on that, there was actually a study on a just transition involving the transportation sector. And when you talk to the stakeholders, the drivers, for example, the resistance doesn't really come from the technology itself. It's the transition to that technology and the cost of that. So it's important to also, and we'll talk about that later when we do the discussion, but also I want to talk about the uncertainties that you mentioned earlier, because the drivers actually are confused as to the policies that they are supposed to implement. And I think we have a couple of government agencies joining us today online and here as well. That might need policy coherence, in other words, is an important factor here. So we'll go to Masako and talk about this landscape in Japan. We'll go to Momita on Bangladesh, and then we'll end the preliminary remarks with Attorney Oposa later, and then we'll go to the discussions. Go ahead, please.
Thank you. Good morning, everyone. Thank you for having me here. As Briony said, I will show you the example of the Japanese legal framework and litigation preference and innovation situation. Specifically, in nutshell, Japan legal system is a little bit conservative example. Specifically regarding climate change law, Act of Promotion Global Warming Countermeasures and Climate Change Adaptation Act, the two major climate change laws in Japan, do not satisfy the justifiability of a threshold requirement of judicial review. On the other hand, the Basic Act of Environment has been referred in an administrative case. Furthermore, the environmental impact assessment has been applied in administrative case, but not civil cases. And however, Japan has a strict regulation on standing, as specified in Article 9 of the Administrative Case Litigation Act. The article notes an action for the revocation and original administrative disposition or action for the revocation of administrative determination may be filed only by a person who has a legal interest in seeking the revocation for the original administrative disposition. So, to satisfy this requirement, the plaintiffs need to prove their infringement of human rights or legal interest. This point partly overlaps with the issue of human rights. So, let me move on the next human rights laws. Constitutional environmental rights, which are not explicitly stated in the Japanese Constitution, have been advocated through interpretation. Still, in civil litigation, fundamental human rights are not directly employed as a cause of action. The health-related personal rights, which is not explicitly stated in civil court, has been developed by case laws. Yet, Japanese courts have been cautious in recognizing such rights. In a recent civil case in Kobe, plaintiffs developed a new cause of action, that is a right to enjoy a stable climate. In the first instance, Kobe District Court dismissed the claim, noting that the imminent dangers and legal causation between the individual emission and the individual damage is required, in which the court did not identify in this case. On the other hand, Japanese courts are still very cautious about the admission of the new developing rights. The right to peaceful and secure life is an injunctive cause of action in the area of climate change litigation. Viewing such claim is still premature as a legal protective interest. The balancing of domestic public benefits and the worldwide damage to be caused by the coal-fired power plants will be another issue where we need to persuade the court that the reduction of CO2 emissions from certain categories of industries should be prioritized. The case is currently pending the Court of Appeal. The appellants argue that their rights should be evaluated as being infringed by the state of the without actually having specific disasters. Specifically, the appellants insisted that being forced to live in a climate unstable world with a temperature increase of over 1.50 degrees Celsius, where life and health are in danger and social instability itself is a violation for their rights. Moreover, they claim that not all CO2 emissions are illegal. Only those that would make it impossible to achieve that 1.5 degree targets. They allege that appeal emissions fall under this category. So, despite the Civil Code Act regarding tort law, despite the Civil Code Article 709, which speculates compensation for loss and damage in torts, no cases have applied in this cause of action thus far. On financial law, it's highly expected that shareholders would challenge business strategies based on climate-related financial disclosures. Regarding consumer protecting law, fraud law, constructor obligation, and planning permitting laws, there have been no cases in climate litigation. So as originally indicated, the newest report from the Graham Institute, the snapshot this year, have a new chapter of, focusing on outside the court. So Japan has a very limited number of the case, but each case has a significant impact. We have experience in late 20th century when we experienced a highly economic development. We have a lot of environmental problem. You know, you may have heard about Minamata disease, which is a very popular environmental problem. But this problem was overcome by the partly environmental litigation. So maybe outside the court also need to be considered in the concept of climate litigation. Thank you.
Thank you very much, Masako. Let's go to Bangladesh with Momita Dasgupta on their framework. If we could, there you go. Hi, Momita.
Hi. Nice to be here, and also it's nice to see Masako there. We are colleagues from Sasamis. So, am I audible?
Hello. Yes, go ahead, Momita.
Yes. Thank you. Actually, I'm having some echoes. That's why I'm a bit confused. So, regarding impacts of corporate activities and sources of accountability, from Bangladesh perspective, I'd like to focus on the sources of accountability very shortly. So, in Bangladesh, presently, the precedents are mainly regarding the environmental litigation. Sometimes people interpret those litigations as climate litigations because there are some impacts from climate perspectives. Like there are some quotations from Rio declarations or others, but those are not actually mainly focused on climate change issues. So it is for court definition, it is difficult to be defined as climate litigations. But the environmental litigations, those are existing precedents of Bangladesh. Those are explaining right to life in such a broad way that life doesn't mean an elementary life or subhuman life. Life means a qualitative life free from environmental hazards. But these explanations are coming from 1996 or 1997. Still, at that time there was no article in the Constitution of Bangladesh regarding environmental right or climate right. But afterwards, in 2011, the latest amendment of Constitution has added the Article 18A, which reflects on protection and improvement of environment and biodiversity, and it denotes specifically for the present and future citizens. It's very interesting that it says about present and future citizens. Usually, the laws in Bangladesh doesn't focus on the future citizens, but this amendment is very interestingly has mentioned about the future citizens also. After this amendment, I can mention two of the cases from the Appellate Division of the Supreme Court of Bangladesh. Those have reflected about the rights of environment, maybe, because regarding the government of People's Republic of Bangladesh and others versus Mohammad Mushfaqur Rahman and another, there was a lease from the government part. But afterwards, the lease was cancelled. The leaseholder claimed regarding this, the lease cancellation was void ab initio. But the court found that the leaseholder cancellation of lease, though it is not legal, but it should be upheld due to it is a ecologically critical area and no construction should be there, and the leaseholder is going to have a construction there. So the leaseholder can claim compensation, but the lease cancellation should be there. So it is focusing on the ecologically critical area, and it is based on the Article 18A. Similar, another case is Rana Surong versus Government of Bangladesh. That is also focusing on environmental benefit based on Article 18A. But yet, the interpretation for the present and future citizens part is yet to be done. It is not yet there in the case laws. Added with this scenario, Section 49 of the Disaster Management Act 2012 has a basis regarding claim of compensation for the human-induced disasters. Yet, it is also yet to be implemented, but this section particularly focus on causing disaster by way of degradation of environment through human activities, either intentionally or negligently. And these human activities cover claim by and from both person and organization. That includes corporation. So that's how it can create a scope for accountability for corporate climate litigation. But the matter is the causation. The causation that this disaster is caused by way of degradation of environment, that is through human activities. It is a matter to be proved, and it is a matter to be shown by evidence. And my previous speakers have said a lot about these issues, so I am not going to that issue anymore. So that's my findings, and looking forward to hear from you and learn from you. Thank you all.
Also the rapporteur for the Sabin Center database. And now before I call on Attorney Oposa, I just want to ask permission from our speakers if I could extend the panel for about 30 minutes before we go to lunch, because we have so many issues to talk about. And of course, I call on now Attorney Oposa, the Attorney Oposa of the Oposa versus Factoran case, which everyone knows, and I thank my students who are forever my captive audience in anything, for coming here. But let's hear from Attorney Oposa himself.
Lights off, please. Dahil nandito tayo, good afternoon, good morning pa. Sa mga Bisaya, mayong buntag. Mayong buntag, oh.
Buntag.
Because we are in Malcolm Theater, this is going to be a participatory presentation, a collective recital. Hindi ako magsasalita, may konti lang salita ako, and then may video na ipapakita. Please, everybody, read it aloud. Turn off the lights, please. Jing. Tayan. So yan. So dito sa UP Law, you are graded. But in this session, you will grace everybody through your words. So, kwento ko lang, may kwento ko. I have tried to use the law too much to care for the earth, but I realized that I got too little done and too late. So, sabi ko, baka kailangan may pagbabago. May pagbabago na, Jeng, ready mo na. May pagkailangan, there is a need for speed. How can we turn climate change into a climate of change? And shifting from enforcement to positive reinforcement. Because, sakadali. Jeng, dali. Can you read it aloud?
Law, try to change the mind.
Read it aloud, please. Kayong lahat. When you change the
Change the
mind,
mind, it can change tomorrow. But when you change the heart,
it is forever.
it is forever. How can we change the heart? How can we change the heart? Oh, the greatest hunger is not the hunger for
Usahin nyo yan.
It is the hunger of the human heart for approval and appreciation. The seeds of goodness grow in the soil of appreciation for goodness. Kind words do not just praise the goodness of others.
Please read aloud. Recitation period.
Kind words have the power to change
Destiny
the destiny
of the world.
and the story of the world.
Sandali. Diyan, dali. Oh. A picture. Oh, what's happening? Yun. Picture is worth 1,000 words. The story is worth 1,000 pictures. Nothing is more powerful than a good story to inspire and set happy hearts on friendly fire. Yun. Kasi walang nakakaintindi niyang environment. Ano ba yung environment? Nakakain ba yan? Nabibenta ba yan sa tindahan? So, we translated it, the land, air, and waters of life. Kung walang hangin, walang tubig, walang buhay. So, that is the backstory of the Good Stories movement. It is a movement that was started.
Attorney Oposa, sorry, can we turn on the lights so we can see you?
No.
Okay.
I like being invisible. Jing, iyon mo. Next, yung good stories. Jing.
The good story. Much of what happens in this
Basahin niyo.
world is not bad.
Oh, it's not bad.
It is neutral, and much of
Much
it
of
is
it
good.
is good.
But why do
Why do
we hear
only
the
the
bad and the sad?
sad?
Because bad news
Bad
sells.
news.
This is all
Yun,
making us
nadidepress tayo
feel
lahat.
depressed, stressed, helpless, and hopeless. No, we are not helpless. We can change the story of the world if we change the storyline.
Hindi. Oh, that's a 3-minute film. Yan ang tanong ko sa inyo ngayon. What good story can you tell us today? kung susulat lang tayo, may ginagawa na nga kaming recognition event last April Earth Day 2023. We gave recognition of good stories event, and one of the nandito si Jerty Mayo Anda was one of the recipients of the international award. So pero may naisip kami na para legit, imbis gagamitin natin yung batas na panglaban sa masama, instead of always fighting the bad and the wrong, can we tell stories of the good, the right, and the strong? Because positive psychology shows that when you highlight what good people are doing, may inspire yung iba. And yun nga, inspiration is the most powerful form of leadership. Ang mga taong inspired tuloy-tuloy lang, hindi presidente. So, may naisip kami na para legitimate at saka maniniwala ang tanungin natin. Oh, next.
Okay, play it.
Let's tell this. What's that? Oh, yun. So, ano mo to? Ano na? Sige na, next. Oo. So, meron, sige, ano mo dito? That is of a legal action. Illegal action lights a star. Ano yung star? S-T-A-R. It lights a star. What does star mean? Next slide. Oh, wait. Oo. It tells a story. It puts the issues on the table for proper discussion. And then somehow or other, it will spark action. And R stands for one way or another, sooner or later, win or lose, there will be a resolution. Bahala na. So yun. Tapos, hindi lang ito kwento, meron kaming naisip na kaso. Hindi kaso na against, it is not people of the Philippines versus, it's called with. And then they're not called respondents, they're called responders. Sila ang sasagot. Anong mga ginawa nilang mabuti? So, meron palang legal basis, Rule 24 sa Rules of Court. Meron na kaming planong ginagawa yan. At tapos, wala lang akong makuhang batang abogado na may puso din na who can help with the manual chores that we need. So, at saka, ang mga pipirma niyan, hindi lang ako kasi bugoy lang naman ako. Kaya ang pipirma, isang pipirma, si Estelito Mendoza. So it will really give legitimacy na maniwala na hindi kalokohan. Ngayon si Oposa, buang lang yan. Pangalan pa lang, upos na. So, because you are all here, you are all dreamers. Sala. So, if you, kayong mga next generation, mga bata, if you continue and do better than all of us, because you have to be at least 10 times better than we are, dahil your challenges are 10 times worse.
Of course, to our participants online, this is the time where you also are able to ask questions. Please prepare for that if you want to intervene. But I want to ask our panelists about a comment made by the Senior Associate Justice earlier about concretizing the right. So as it stands in the Philippines, for example, we have the right to a healthful and balanced ecology, which is broad enough to encompass all these things. But in terms of litigation and achieving success in litigation, what do you think about making that right more particular, or do we think that the rights that we have now as a basis for a cause of action would be sufficient to accommodate creative theories about liability? Anybody can.
So, so I think it's important to understand that there are human rights, but often the way they're internalized domestically is in constitutional rights, because human rights law lacks enforcement mechanisms. And the Philippine Commission on Human Rights acknowledged that in saying we can only really issue essentially an advisory opinion or a finding on the outcome of an investigation. So what's always critical is you need to follow that through to what are the remedies that you can ask for. And so that's why in South Asia you've seen a lot more constitutional environmental litigation, because in those jurisdictions courts are empowered with very broad powers to remedy violations of constitutional rights. It's difficult here in the Philippines because the right to a clean and healthful ecology is not within the rights portion of the Constitution. It's a directive to the state. So that makes it difficult to find a mechanism or a remedy that you can use. So I think any litigation needs to be grounded on some hook. So use rights for sure, but that's the challenge. Like the Segovia litigation about air pollution, that didn't succeed because there were not remedies that could be granted in that particular circumstance. Contrast Indonesia, where there was air pollution litigation, and the court found that the government had failed in its duty, its obligation to ensure that there is clean air. So it may just need nuancing, but I think that's why we see different types of litigation in corporations law, where there might be some remedy that you can have enforced, in torts law, where you can enforce a remedy. So it's really up to the litigators to look for the hooks for the remedies, and you can fuse different areas of law, but that's probably the challenge with human rights law, is to find the hook.
Thank you very much. Yes, Judge Ivy and then Professor Jackie.
I find that there are reasons for why we should concretize the human right to a balanced and healthful ecology. The first one being, it allows us to avoid judicial legislation. It's so broad that, when judges feel like they want to be more creative, they could be prone to interpreting that in ways that may be more detrimental rather than helpful. And also, we really have to respect the separation of powers in that regard. We leave it to the executive, we leave it to the legislative, how that looks like within their ambits of control. The second one is that what we have observed in jurisprudence, all these cases that we've spoken about, they didn't just, well, most of them, they didn't just get to the Supreme Court. They had to go through the trial courts. And what we see is that there is a hesitation among trial court judges to resolve environmental cases, specifically climate change cases that we will be seeing in the future, because this is novel. We may not have enough guidance in our rules. We may not have enough guidance in our jurisprudence in really resolving what the rights are and declaring what the duties are, and in evaluating whether the evidence supports the allegation that there is a breach. And so allow the concretization of that right to a healthful and balanced ecology would help, especially the judges in the trial court sort of have some specificity as to what to look for in the cases that are filed before them.
Hello? All right. So the right to a balanced and healthful ecology in the Constitution was kept deliberately vague so that there would be a sense of flexibility to cope with the changing needs, requirements, and demands on our environment. I guess the key to understanding this too is understanding what are the components of a balanced and healthful ecology. And we see that this is reflected in various specific legislation, and then that sort of is read together with how we are supposed to operationalize this demand on our government to give us a right to a balanced and healthful ecology. To that, I will also add that a barrier, and I think this has already been mentioned by my esteemed panelists, a barrier to being able to enjoy this right to balanced and healthful ecology are some sort of procedural difficulties in trying to propound these rights. So Saj Leonin mentioned earlier that there is now a process for re-examining the rules of procedure for environmental cases to consider or reconsider the issue of standing, whether or not the rights of nature will be considered, so to speak, precautionary principle, that sort of thing. So all of this, this process of specific legislation and the re-examining of the procedural aspects of litigation will help give substance and meat to this right in the Constitution.
Thank you, Jackie. Sorry. Well, we're with you. Just on the matter of enforcement and I suppose domesticating BBNJ, for example, or the UNCLOS, do you see a way through the right to a healthful and balanced ecology? Is it a component of that, or do we need to anchor a suit based on an international commitment that we've made?
I think it would be a more straightforward process if you would be able to formally domesticate it. So like right now, there is currently an ongoing process to study whether we can adopt domestic counterpart legislation in anticipation of the BBNJ agreement taking into effect. By the way, I didn't say earlier, it is not yet in force, so it's just open for signature. So hopefully we reach that goal of at least 60 states ratifying it for it to become effective. But the Philippines has been a leader in this process. So for us to be able to reflect it in domestic litigation processes is something that I anticipate will be happening through local legislation that sort of reflects the core principles of the BBNJ agreement.
Thank you. Professor Bob, on the matter of, we're working on water access, water rights. And so if we confine litigation, for example, to the Clean Water Act and related statutes, do you think that it adequately captures the climate change phenomenon, or do you think that anchoring it on specific environmental statutes will just silo the issue and not really present it as an impact of climate change?
I think one point of your question that needs to be further unpacked is how do we make that claim? And you go back to the due diligence process of how do we collect data and how do we support one position or another. I come from the United States. I spent about 30 years working in the environmental remediation industry, dealing with litigation with my clients, oil companies, who had polluted the land, water, preparing for a trial in that context, the amount of data we had to collect, the quality assurance and quality control measures to go through the analysis of that data to prepare it. Now working in the Philippines on that problem, when we look at the limited amount of information we have, how do we actually make that, make that claim or support it through data? I find that to be a very large challenge. I mean, we study the process of saltwater intrusion on island landforms. It's a very common problem around the world, and it's actually taking away water supplies from people. Not because of someone pumping it, but because it's being polluted. When you look at point source pollution from an industry, or in some cases poultry, or non-point source pollution from agriculture, when that water is polluted, there's a volumetric loss in the water because it's contaminated. Therefore, people are going to be deprived water. So it's how we build that data set, how we support this process to actually, because you can go out and identify people who are suffering, they don't have access to water, the water they have access to is polluted, they're forced to purchase water. But trying to link the cause to that is where we need to have more people in the field. We have to have political will to enforce laws that exist. And sadly, we don't see that in some of the provinces, for sure.
For our panelists and of course, Attorney Oposa, you are included in this, and feel free to respond from Japan and Bangladesh as well. So just let's flip it to duties. So while we talk about rights, in your jurisdictions, do you have frameworks that talk about corporate duties in this space outside of the traditional spaces where we would expect the law will impose obligations on corporate entities?
Thank you for your question. Yeah, in terms of the general principle, we have the no harm principle, and currently the UN guideline for human rights of business sectors is gradually spreading in Japanese companies as well. So in the at least in the context of the soft law or guideline, many companies are applying protecting the law, and in specific area, maybe they have some regulation to not to prevent pollute outside of their area. And, we have a lot of jurisprudence in terms of environmental pollution. But let me add one point, as I said, one of the difficult points of climate litigation is invisibility of the damage, because when we consider the Minamata case or other pollution case, the victim is very clear. They have some health problem. It's very visible. But the climate change litigation, most of plaintiff is just facing some crisis or imminent danger. So if many decisions say it's not concrete as materialized. So that point is, I think, is very difficult point.
Thank you. Momita, if you have any insight, or Atty. Oposa, feel free. But I want to just interrupt me, please, if you have anything to say. But I want to spring from that and talk about the commercial law area. So a lot of the remedies that people, especially younger generations, have been using is the remedy of a boycott, for example, of a particular company's goods or services. But in court, if we can translate that into litigation, are there any developments in the corporate laws area where we can imagine a suit based on people being commercial actors, outside of being, let's say, human rights advocates or tort law practitioners, but as commercial actors or consumers even? Do we see any movement in this space? Briony?
If you
Yeah.
say about the corporations,
Oh, sorry. I think Momita is saying something. Am I hearing her? Okay. We'll call on her again. And
Again, that really differs around the world. And you mentioned, I think earlier, you had McVeigh and Rest someone had McVeigh and Rest. By the way, Tony, in Australia, it's not versus, it's and. So we don't use versus. But McVeigh and Rest, Abrahams and Commonwealth Bank of Australia, a lot of corporations-based lawsuits looking at directors' obligations to disclose risk, directors' obligations to bring their policies in line with the Paris Agreement. None of these are based on rights. They're not based on human rights. We have a constitution that is absent of any human rights in Australia. So they're all based on what are the obligations of companies to disclose climate risk to the market, because that impacts their shareholders. So we're seeing that litigation in the UK. Somebody mentioned the Climate Earth and Shell decision, which was a rather disappointing outcome. We're seeing a lot of it in Australia based on these duties of disclosure or duties to bring the policies in line. So there are those. And then also there's the litigation in Europe, the Milieu Défensier case against Shell, which was in the Netherlands, finding that within the law there was an unwritten duty of care for Shell to meet particular obligations around emissions. So yes, we are seeing a lot of corporate climate litigation around those areas.
Thank you. In the Philippines, for example, do we see that happening? Let's say Jackie in obligations or judge in your courts. Okay. Yeah. Well, we're thinking of.
We don't. I think that's a straight answer to that. We don't. It is one of those where it's under theorized, under practice parts of law, that environmental and climate litigation that we still have to advocate more for and see more in courts so that we're able to really suss out where are the duties, where are the rights, and how does it look like? How do we make them tangible?
So on that note, Jackie, sorry, are corporations at all participating in this conversation on the BBNJ or the UNCLOS?
Yeah, actually, they did participate actively during the negotiation process, recognizing that it would have significant impact on them. There's a cost perspective here that sort of factored into it. And there are, like I said, there are so many private sector activities, because actually it's not states that have presence in marine transport, in high seas fishing and those sorts of activities. It's private corporations. So in that sense, they wanted to build in some flexibility in the standards so that down the road liability isn't necessarily a foregone conclusion, but would have to conform to strict standards for measuring behavior.
Okay. And maybe to tide it over, and I know this will be the last. Momita, yes, do you want to say something?
Yes, yes. Am I audible now? Okay, thank you. So regarding Bangladesh, if you say about corporations, I can say about Environment Conservation Act 1996, 1995. And it has Environment Conservation Rules 1997 that is now again revised and newly adopted in Environment Conservation Rules 2023. These conservation rules has annexed a list of categories of industries, and those are categorized at red, orange A, orange B, and green. So these categories have all of these categories have different sets of commitments as defined by the law, and different sets of precautions to be taken by each of the categories of industries. So if these precautions are not taken, then suits can be brought in the court, and Environment Court is there, Environment Court Act 2010, and it was previously 2000. Now it's revised in 2010, but the matter is it is broadly dependent on the government, because the first step is to become from the government, and there is a very little scope of general people to go and sue against any corporation, but there is scope, but very limited scope. So that's a question to be discussed in broadly, but to say shortly that there are corporate liabilities in Environment Conservation Act and supported by environment conservation rules. And regarding constitution, yes, environment-related right is inserted in the fundamental principles of the state policy. That's not included in the fundamental rights. But as I stated in my presentation, court has several times taken the opportunity to explain, to interpret the fundamental rights in the light of fundamental principles of state policy. So that's how it can be covered, but it is yet to be covered. So that's how I think. Maybe different people have different views. Thank you. Are you asking something? I can't hear you.
No, yes, I'm asking the panel on remedies, actually. So, and some of these strategies that we have might involve more investments from corporations. So for desalination, for example, we'll need investments from entities. And so, where are we going in this direction? Are corporations participating more despite the risk of litigation, or actually the risk of litigation in intervening in any of these mitigation and adaptation strategies is a deterrent to corporate participation at all? And so, because in anywhere you go, you might run the risk of being, brought to court for not doing enough or doing something that is inconsistent with a particular framework. So where are we going in this space? Are corporations intervening more at the risk of litigation, or are they not doing that?
Yes, corporations are participating, and again, somebody mentioned reputational risk is a really significant issue, and you mentioned boycotting. So there's the Climate Action 100 Plus initiative. There are initiatives by investors, global investors, who are saying we no longer wish to invest in corporations with heavy climate risk. So there are many corporations that are making an effort. And yes, it does sometimes lead to risk. And one example is in Australia, Santos, which is a big fossil fuel company, is a member of Climate Action 100 Plus, saying we're going to reduce our emissions. So it made certain statements, but then it got sued for greenwashing because its statements don't align with where it's going. But that doesn't mean that companies aren't trying, and that there aren't many companies that are making statements and shifting in their climate policies. So, for example, I mentioned before the case against the Commonwealth Bank of Australia had been refusing to disclose its corporate risk, its exposure under its loans. When it was sued, it was actually a consensual agreement, so they decided that they should be disclosing their risk. So it is changing behaviour, and I think I just want to come back to adaptation quickly, because there is litigation in the US against companies that have failed to ensure that their infrastructure is resistant and resilient to climate change. So I would think that might be fertile grounds in places in the world where there have not been high emissions, but where you have oil companies with infrastructure close to the coast that could be wiped out by a big typhoon. There are cases around the world that are looking at that, and I think as all companies look at their corporate risk, I think they are considering what their exposure is, not just to litigation, but to climate events, but also to the transition risk, and the fact that transition risk means there are shifting regulatory and legal environments, and there are shifting preferences in consumers and what consumers expect of them. So yes, they are participating.
Thank you. Jackie? Professor Jackie?
I absolutely agree that corporations are really joining this conversation and taking active measures to sort of signal that they are also being responsible actors in this space. So on one hand, you have all of this conversation about things like eco-labeling, which runs the risk, of course, of being subject to greenwashing and saying that you're trumpeting that you've done this or that, you've sourced this from this production line or something like that, which is supposedly green, so to speak. It may be a case of sort of putting the cart before the horse, that you have already achieved this and that target without necessarily doing something concrete. But signs point to the fact that they're doing this because the public demands it, shareholders demand it, and they're responding to that. Again, it goes back to the notion of reputation. So it's apparent to me that the trend really is to sort of have an agenda that is aligned with public interest right now, because otherwise you would run the risk of, to borrow Gen Z language, you could get canceled, and that is something that could translate to actual litigious processes that companies want to avoid, because it's not just about the litigation itself, but there could be a massive reputational damage which should have commercial impact. I had another point, but I just lost it at the moment, so I will yield the floor.
Thank you. I totally agree with Jackie. I need not only the behavior demanded to the company, but also the raise of awareness of the consumers is needed, because if the consumer requires environmental friendly, truly environmental friendly, the company is forced to change their behavior. Currently, the climate washing area is emerging a new area of the climate litigation. Actually, one Japanese defendant, Zero Company, is advocating advocating that they develop the zero emissions fossil fuel power plants, which is not based on the scientific improvement. So maybe awareness of the consumers is also important.
From the research perspective, I see corporations embracing the challenge. But when you mention the word research, they kind of step back. Their experience, especially with water, is since water is an extremely social issue, and it's a very local issue, and it's best solved at the local level, we're working on an investigative project now where we're doing an inventory throughout the country of the Philippines for islands that rely solely on a certain type of aquifer. And that aquifer, and it encompasses almost 160 islands in the country. And Coca-Cola has been very interested in this research through their environmental foundation. But what their interest is in capacity building. Once we go through all the identification and classification and then prioritization of these islands, they want to be involved in that component. From my perspective, I'll welcome any support, just as long as we can move the needle. And then with respect to desalinization, there's a group of smaller islands in the country that really can't even support an aquifer, yet they have a growing population. And now the DENR is supporting desalinization plants on these islands. But the metric really to run an effective plant is through a community-based organization or a CBO framework where the plants can run autonomously and earn enough income to support the operation of the plant, which you can only imagine could be quite complicated to measure. So I think there's good things happening with involvement and support from both government and corporate. But there's a long way to go.
There is participation from corporations, and I say this because in my past life, I was a grant writer for a civil service organization, and what we've seen is that they do want to participate in climate initiatives as rolled out by smaller NGOs or CSOs. It's just that the crisis that you would have if you were working for that NGO or CSO is that, yes, you want to participate in this awareness campaign, say, project, but is that enough participation on your end to offset your carbon footprint? So that's one question. And then the other one in terms of litigation is that, yes, they are participating, but often at the compulsion of the law. Why do we say that? Because they are the respondents, they are the defendants, they are the ones who, by a writ of continuing mandamus, need to submit quarterly reports to the court to see how they are complying with their duties under specific environmental laws. And so really, at the end of the day, we have to appreciate that this problem is a problem for everyone and that it will not be solved by law alone, it will not be solved by litigation alone. There has to be real participation, not just from the corporations, but from the communities. And I will digress a little bit. Last month, I was in Batangas. I did a scuba dive. And the story from my dive master was that they were trying to reinvigorate the coral life in that area of Batangas. And so they were installing artificial reefs, they were installing solar panels because the corals grow faster when you electrocute them, apparently. But what happened was that the fisher folk, the residents, would steal the solar panels. They would destroy the reefs, they would catch the smaller fish, or they'd release it, but they'd release it somewhere where on top of a rock where it couldn't breathe, where it doesn't have access to food anymore. And so really there needs to be sort of congregated efforts, and maybe we are doing this in the right direction today because we're starting with the awareness.
Thank you very much. Mamita and Atty. Oposa, if you wanted to say something? No? Okay, you're good. Okay, Mamita? All right, it seems like there is none. So I really want to thank our panelists for joining us this morning. I know it took some time to talk about the questions, but it's a fruitful discussion, I think, that will set the tone for the rest of our panels today on procedure, evidence, and remedies. We want just to give you certain tokens before we leave, and then of course we have lunch after. Thank you very much.